In this session, I will take you through an occasion that the Child Poverty Action Group has used a judicial review pre-action protocol letter to resolve a client's welfare benefits issue that was otherwise unresolvable or intractable. So I'm just going to share my screen and do that. Okay, so in this case, an advisor referred a client to us who was an Irish national and who had 3 young dependent children. And she was in Great Britain with no income and no housing. She was sofa surfing, I think, at the point she was referred to us, and was destitute. She had no income of her own. She had been relying on handouts from friends and family, I think. She had no national insurance number. She had made an application for a national insurance number through the national insurance number claim line sometime previously, and was waiting for that national insurance number to be issued. She had provided all the information that they needed in order to issue a national insurance number, but one had not yet been provided to her. She made an application for universal credit. Universal credit said, we acknowledge that you are eligible for universal credit. You have a right to reside, you meet all of the criteria. However, we cannot pay you the money that you're eligible for until you have a national insurance number. So at the point she came to us, she'd had 2 months with no income at all. She was referred to Child Poverty Action Group on a Wednesday. So we drafted a pre-action protocol letter, which we sent on her behalf. And in that letter, we set it out. We had background facts, so all of her circumstances, what had happened, what DWP had said, information that she'd provided. And then in this instance, we combined the legal background, so the relevant legislation and case law and guidance, with the grounds for judicial review, because it's quite a short issue. So if you look at the templates on our website, you'll see some of them that's set out separately. So you'll have legal background and then grounds for judicial review. But in this case, we combined the two. So ground 1, failure to follow the law, failure to follow the legislation. So the legislation is clear on this. Section 1 of the Social Security Administration Act 1992 provides that the national insurance number requirement may be satisfied where the claimant provides a national insurance number or evidence or information necessary to ascertain a national insurance number, or, crucially, the person makes an application for a national insurance number to be allocated to him, which is accompanied by information or evidence enabling such a number to be allocated. So remembering that she had made an application for a national insurance number, had provided the information or evidence, and it was pending. She was waiting for that national insurance number. Further, DWP, you have failed to follow the case law. The relevant provisions of the Social Security Administration Act were considered by Commissioner Rowland in the Upper Tribunal, where he said the payment of benefit is not generally to be delayed while the application for the national insurance number is processed, which is exactly what was happening in this case. Further, we said, DWP, you're failing to follow your own guidance. The advice for decision making confirms that an award should be made where a national insurance number has been applied for. There is no entitlement to benefits unless the claim is accompanied by sufficient information or evidence to enable a national insurance number to be allocated where the claimant does not have a national insurance number and they apply for one. So that's all very clear. So it's a very clear-cut issue, is that you are entitled to universal credit or other benefits once you have applied for a national insurance number, provided the relevant information or evidence needed to support that application, and you're waiting for it to be processed. Payment should not be delayed while you're waiting for it to be processed. What did we ask for? We asked the DWP to, without further delay, award and pay our clients universal credit from the date of her application. We asked them to amend their system to enable payments to be made without any requirement for an actual national insurance number, provided that an application for a national insurance number has been made, and to remove the misleading requirement on their website, How to Claim, where it said what you need to apply, your national insurance number. We requested a response by 5 p.m. on the Friday of the same week. What did we get? So they said, as you're already aware, the proposed claimant applied under the employee route for a national insurance number. And what that means is that she applied by phoning the national insurance number claim line rather than applying for universal credit without a national insurance number and allowing the job centre to initiate a national insurance number application for her. And that is a result of a previous a workaround that DWP introduced to avoid claimants experiencing a disadvantage because they don't have a national insurance number, whilst at the same time not enabling the universal credit system to pay somebody when they don't have one. So it's a way of, yeah, it's a workaround to avoid any disadvantage being suffered by those claimants. However, it doesn't address the fact that a claimant might have applied for a national insurance number and might need a universal credit advance. So the workaround is that a national insurance number will always be provided before the first payment of universal credit is due. However, what about people who need an advance? Anyway, an issue we are still interested in. We have taken steps to address this, and payment should be made today or early next week. They rejected all our arguments of unlawfulness, which is not uncommon. Every single time they will not admit that they have acted unlawfully. However, payment was received on the Wednesday of the following week, along with her national insurance number. So there you see the operation of the workaround is that we are not going to pay her without a national insurance number, but we will make sure that she has a national insurance number so that we can pay her. They did amend their webpage, so if you visit that webpage now, you will see that it no longer says you need your national insurance number in order to make a claim. And they issued a staff memo to all job centres detailing the procedure which staff must follow in these circumstances, which is if somebody applies without a national insurance number, you make a national insurance number for them, or you start that national insurance number application for them. So I've put in here a common wording of a DWP response, and just to flag up, again, they might respond to you. You might have up to 4 A4 sides of DWP saying, no, we don't agree, we do not accept, we've acted unlawfully, you are so unreasonable to have brought this to our attention. However, it's always worth looking to the end. If you're feeling disheartened, skip to the end and see if in fact the issue has been resolved. So this is one example. Judicial review is a remedy of last resort. The claimant must exhaust all other remedies available to her before issuing judicial review proceedings, which is correct. It is a remedy of last resort. In this case, the appropriate means of challenging the Secretary of State's decision is to pursue the statutory appeal route. It's worth saying there, if the appeal route is open to your client, if there is a right of appeal, they must use it. Because judicial review is a remedy of last resort, because one of the ways that using the pre-action protocol is effective is to influence other decisions. So, for example, a mandatory reconsideration decision, and because there is a time limit to appeal, and you don't want to miss your time limit because you've been using the pre-action protocol. So you can do both if it comes to it. If you've got a reason to use judicial review, use it, but you can also appeal to protect your client's position. The claimant has begun this process by requesting a mandatory reconsideration. The mandatory reconsideration has now been carried out, and we accept that the claimant has a right to reside and is eligible to receive benefits. A decision will be sent to the claimant to that effect in due course. We hope this is a satisfactory result for your claimant and no further proceedings will ensue. So that's where DWP have resolved the issue for the claimant, not accepted any wrongdoing, but resolved it for the claimant in order to avoid any legal proceedings, which are, as I've discussed in other sessions, very timely and expensive. So if there is clear unlawfulness, the easiest thing to do is to resolve the issue for that client or that claimant. And that's what you want as an advisor. Your role is to support your clients and to resolve their issues for them, make sure they're getting the money that they're entitled to. It's a way of achieving that. So here's some feedback on different issues that we have prepared templates on, which are all available on the website, which again, there'll be another session on how to use the website, how to access our resources and how to use those resources. So first off, similar to the one we've just looked at, refusal to pay universal credit because there was no national insurance number, but somebody who'd done it on their own behalf, or not on their own behalf, but on behalf of their client, not with CPAG. I followed your advice and sent DWP a letter of JR based on your template. It worked. By the end of April, the client was paid all the universal credit due. We've done a number of letters on delays, particularly because there is no right of appeal when it's a delay. What you're challenging is the delay to make a decision, and there is no appeal right there. So judicial review is the obvious way of challenging that. So delay processing a monetary reconsideration request. Thank you for your template, which had the desired result of providing us with a written monetary reconsideration outcome decision, which we can now appeal after nearly 6 months of waiting and a conciliatory payment of £50 to the client for unavoidable delays. So notably there, the issue was not resolved for the client in that a monetary reconsideration decision was not made in her favour, but it opened up her appeal rights. So it was still successful, but not in the best way we would have hoped for, but it opened up her appeal rights. And then I don't know if she went on to be successful at appeal, I don't know. And she also got a £50 conciliatory payment, which I have not seen before or since, but it could happen. Real-time information feed dispute. So referring to Universal Credit Regulations Reg 61 and CPAG's JR pre-action protocol letter in an RTI dispute, today led to Universal Credit revising their decision in her favour, and she has received a same-day payment today. The payment was very helpful in framing the monetary reconsideration request. So notably there, they've used one of our templates, but not to send a judicial review pre-action protocol letter. They've used the legal arguments in drafting their monetary reconsideration request. And we're very comfortable with you using the materials that we make available in whatever way helps you and helps your clients. So do feel free, if we've had feedback that people have used them in drafting complaints and monetary reconsideration requests and appeal submissions, that, you know, they're there for you to use. The terminology needs changing slightly, obviously. And if you need help with that, then do get in touch. The revised decision means that she can now book an online grocery delivery. From memory, I think that was somebody who was undergoing chemotherapy, cancer, undergoing chemotherapy, and had been unable to afford food or gas or electricity. So yeah, that was a really good outcome for her. Delay in implementing a positive habitual residence test decision. So again, this is challenging a delay. Just thought I'd let you know that the pre-action letter worked. The client is very happy and she's just received a backdated payment and her regular payments will commence on 17th. So good news. Somebody again who'd done it themselves without our intervention. Refusal to pay contribution-based ESA pending an appeal. Pre-action protocol papers were sent and emailed on the 21st of June. Client received a text on the 28th of June, so a week later, advising the money would be in his account the same day, and received £1,012. This was our office's first pre-action letter, so we are over the moon. Shandy's all round tonight, not that we advocate drinking. So it's just to demonstrate that you don't need to be a solicitor, and the templates are there for people to use. You don't need to necessarily have any experience in the area before using them, and we can support you if you're unsure what you need to be doing. Finally, advanced claims for care leavers. I attached the response from the DWP solicitor after using the template you prepared for me. Although they do not accept our view, they've given my client the missing days of universal credit. So again, there they have, they've not accepted that they've acted unlawfully, but they've resolved the issue for the client. And that's what you're really setting out to do. That's a successful outcome. Okay, so here are my contact details. So if you get in touch with jrproject@cpag, that will come through to me, and I can help you in any way that I can. The template letters are on that link there. I will do, as I said, a separate session on how to access those. And then you can look at some other case studies if you want to see how it's worked in practice for other people there. I think that's all for this section. Thank you very much for watching, and please do watch the other sessions and do have a look at the website and the resources that we've made available, and do get in touch if you have any issues that you think could be addressed by using the Judicial Review Pre-Action Protocol, or you want help using any of the templates, or you want to draft a new template. Thank you very much.